In this video, I'm going to walk you through exactly what rights you have as a shareholder on the Florida Business Corporation Act, and more importantly, how to protect yourself when those rights are under attack. I'm Santiago Cueto, board-certified international business law expert and best-selling author. Over the years, I've represented countless shareholders in Florida disputes where they didn't understand their statutory rights until it was too late. Today, I'm breaking down everything you need to know about Chapter 607 of the Florida statutes so you're never caught off guard. Let me start with something most people get wrong. When you become a shareholder in a Florida private company, your rights come from three different sources. First, the Florida Business Corporation Act in Chapter 607. Second, the company's Articles of Incorporation. And third, any shareholders agreements that you've signed. Understanding how these work together is critical because Florida law provides default rights, but many of them can be modified or eliminated by the company's governing documents. Now, the first fundamental right you have under Florida law is the right to information. Florida law gives you automatic right to inspect certain records at the company's principal office with just 5 business days written notice. This includes articles of incorporation, bylaws, board resolutions creating share classes, minutes of shareholder meetings from the past 3 years, and the list of current directors and officers. No reasons necessary, no objection allowed, but here's where it gets more complicated. If you want to see board meeting minutes, financial statements beyond what's automatically provided, or accounting records, you need to meet a higher standard. Under Chapter 607, you must demonstrate that your demand is made in good faith, for proper purpose, and describe with reasonable particularity what you want to see and why, and show that the records are directly connected with your purpose as a shareholder. The statute even imposes a $5,000 penalty if you sell or distribute information obtained through inspection for an improper purpose. Now let's talk about voting rights under Florida law, because this is where shareholders get blindsided. I've seen it happen all the time. Under the Florida Business Corporation Act, companies can issue different classes of shares with different voting rights. This law specifically allows shares to have special, conditional, or limited voting rights, or even no voting rights at all. I've seen Florida investors put hundreds of thousands of dollars into a company only to discover they hold non-voting preferred shares and have zero say in major decisions. You heard that right, zero say in major decisions. Now here's what you actually get to vote on under Florida law. Shareholders typically vote on electing directors, approving mergers or share exchanges, amending the Articles of Incorporation, and dissolving the company. But day-to-day management belongs to the board of directors. You don't vote on hiring, vendor contracts, or operational matters. Florida law also permits weighted voting structures. Under Chapter 607, shareholder agreements can establish weighted voting rights where one person's shares count for more votes than another's. This means founders can retain super voting shares, giving them 10 or 20 votes per share, while your shares only give you 1 vote each. So if you own 30% of the economic interest, you might control only 5% of the voting power. This is perfectly legal under Florida law if it's properly documented in the articles or a shareholder agreement. And speaking of understanding your position under Florida law, if you're finding this valuable so far, hit that like button right now. It helps other Florida business owners find this critical information. And subscribe to my channel because I break down complex Florida business law every week in ways you can actually use. Now let's move to economic rights. Under the Florida Business Corporation Act, there is no automatic right to dividends. The board of directors has complete discretion to decide whether and when to declare distributions. I've represented shareholders in profitable Florida companies that went decades without paying a dividend because the board decided to reinvest everything. Unless the Articles of Incorporation or a shareholder agreement specifically requires distributions, you have no legal right to demand them. This is why understanding liquidation preferences become critical. While the statute doesn't mandate liquidation preferences, they're commonly negotiated in private company investment. Let me give you a Florida example. Say you invest $50,000 for 10% of a Miami-based corporation. 3 years later, the company is sold for $2 million. You expect $200,000. But if later investors negotiated a 2 times liquidation preference on their $1 million investment, they get paid $2 million first. That's the entire sales price. You get nothing, even though there was a substantial exit. Florida law permits this through the Articles of Incorporation. Florida also has unique provisions under financial reporting. Under Florida law, every Florida shareholder is entitled to receive annual financial statements within 120 days of the fiscal year end. This includes a balance sheet, income statement, and statements of cash flow. And now, if a public accountant prepares them, their report must accompany the statements. If not, an officer must certify whether they follow generally accepted accounting principles. This is an unqualified right you have just by being a shareholder. This brings me to protective rights, which under Florida law are primarily established through shareholder agreements. This law is powerful. It allows shareholders to create binding agreements that can govern voting, management, dividend policy, and even transfer restrictions. These agreements must be signed by all shareholders to bind the corporation, but Florida law gives you tremendous flexibility to negotiate protective provisions. Common protective rights include veto rights over additional debt, blocking the sale of the company, preventing dilution through new share issuances, and requiring unanimous consent for certain major decisions. I always tell my Florida clients that if you're investing as a minority shareholder and don't negotiate for protective rights in a shareholder agreement under Chapter 607, you're at the mercy of the majority. Now, there's also the issue of preemptive rights. Under the Florida Business Corporation Act, Florida shareholders do not have preemptive rights unless the Articles of Incorporation specifically grant them. This is a critical default rule. Without preemptive rights explicitly stated in your articles, your ownership can be diluted to almost nothing as the company issues new shares. If the articles state that the corporation elects to have preemptive rights, then you get the right to acquire proportional amounts of new shares before they're offered to outsiders. But this must be in the Articles of Incorporation. I've seen Florida founders go from owning 20% of the company to less than 2% after multiple funding rounds because this protection wasn't in place. Finally, let's talk about exit rights and legal remedies under Florida law, because in a private company, you can't just sell your shares on a stock exchange. Florida provides several statutory remedies when things go wrong. First, there are appraisal rights. If the company undergoes certain fundamental changes like a merger, share exchange, or disposition of substantially all assets, and you're entitled to vote on it, you can dissent and demand that the company pay you the fair value of your shares as determined by a court. Now, the procedures are strict. You must file written notice before the vote, not vote in favor of the transaction, and make a demand for payment. But this gives you an exit when major changes occur. Second, Florida law provides for derivative actions. If the corporation is harmed by wrongdoing of directors or officers, you can sue on behalf of the company. The current version of the statute requires you to make a written demand on the board of directors and wait 90 days unless you allege in your complaint why making a demand would be futile. This is a powerful tool for minority shareholders. Third, Florida law allows shareholders to petition for judicial dissolution in specific circumstances. If directors are deadlocked and shareholders can't break the deadlock, causing injury to the corporation or preventing business from being conducted to the advantage of shareholders, you can ask a Florida Circuit Court to dissolve the company. You can also seek dissolution if corporate assets are being misapplied or wasted, or if directors are acting illegally or fraudulently. Now, here's what makes Florida law particularly protective. When you file for judicial dissolution, the other shareholders or the corporation can elect to purchase your shares at fair value instead. This creates a buyout mechanism even when there's no agreement in place. It's a powerful exit strategy for minority shareholders trapped in a deadlock situation. Look, understanding your rights as a shareholder in a Florida private company isn't just about knowing what's in Chapter 607. It's about protecting yourself before you invest by getting the right provisions in the Articles of Incorporation and shareholder agreements, knowing when to exercise your statutory rights under Florida law, and understanding the remedies available to you when things go wrong. The shareholders who win in Florida are the ones who understand these statutes, negotiate protective provisions up front, and enforce their rights when necessary. Now, if this deep dive into Florida shareholder law opened your eyes to rights you didn't know you had under Chapter 607, make sure you subscribe so you don't miss future breakdowns of Florida business law. And if you found this helpful, drop a like on this video. I'm Santiago Cueto, your Florida business law attorney.